delay. This is the Radnor Township Zoning Board for February 16th, 2012. Our first appeal is Appeal 2868. The applicant, Bruce Trottenberg and Lisa Cohen, property located at 230 South Wayne Avenue, Wayne, Pennsylvania, and zoned R3 residential. Applicant seeks relief to construct an addition to the rear of their home, which is closer to the property line than the required side yard setback. Applicant seeks a variance from Section 280.25D1 of the Code relating to the side yards and aggregate side yards. This appeal is continued from the January meeting. Mr. Keneally?
Good evening. I made an additional exhibit. You may recall we were here last time. The board asked us to come back. I've marked as A10 a plan that indicates basically what you may recall that the last plan asked to go within 7 feet of the property line. The existing home is currently 10 feet from the property line. There was a non-conformity. I'll backtrack. The house was built pre-zoning around the 1900s, before the 1900s. When it was built, it was 12 feet from the property line. The code currently states that it has to be 15 feet from the property line. Back in the 90s, the former owner came before this board and got relief to construct along the 12 feet and even to go 2 feet closer, to go to 10 feet from the property line. So you got a special exception for up to 12 feet and then a variance for the area up to 10 feet. Our initial proposal was to construct an addition that would further encroach by 3 feet. We prepared a plan that I've marked as A10, and we've actually cut that back to that it would encroach. It would be 8.5 feet from the property line. As I said, the current area is 10 feet. The area that it would encroach beyond the 10 feet is 7.8 feet, so square feet, that is. It's 1.5 feet closer to the property line, and the total square footage that it encroaches is 7.8 feet. And I'll hand these up to the board here.
The record what you go to, Sean. I just read it.
You may recall the board asked for us to do a little better plan too, because the last one was in block, and so this has been prepared by Peter Batchelor, a registered architect, and you'll notice he shows the 12 feet, which was the existing nonconformity, the shaded portion in this area. That's the Yeager addition is called, which was back in the 90s. And you'll see this shaded area is the area they extended beyond the 10 feet, so they or beyond the 12 feet, so they extended it 8 square feet to 10 feet. We're proposing to go to 8.5 feet, which would be an additional 7.8 square feet beyond the 10-foot property line. You may recall when we were here last time, the board suggested that we come back with another plan and basically to lower the amount of the impingement and also to show them how much what the square footage was that we were encroaching.
Actually, it looks like there's two different tests. It's both the aggregate that's going to be further nonconforming and the sideline on the one side.
That's correct, because the Yeager, when you look at it, yes,
We're
that is
making
correct.
both nonconformities worse by doing this.
Yes, I would agree, because the aggregate would be here, and obviously by putting it closer to this property line, we're further reducing the aggregate as well.
And Nick, as you recall, the last time, the problem I had, and I think the rest of the board shared the issue, was that even an accessory structure in this zone isn't allowed to come closer than 10 feet to a property line. And this is the principal building that you're asking to come within 10 feet of the property line. There's no way to do this? I mean, couldn't this wall just be moved over a little bit to the left and looking at this plan, whatever direction that is? I don't see a north arrow here, so I'll assume north is up.
That's South Wayne Avenue along the front here. So north would be towards the right. So the impingement actually is going north.
Yeah, here's
you
the
will.
arrow here. So,
Well, on this little plan, there's an arrow?
no, not on the little plan, but on
Oh, okay.
what's been marked as A6, there's an arrow, which it looks like South Wayne would be kind of
It's a little
north to
confusing,
some
because the
extent.
plan you gave us last time had the triangle going one way, and this has the other way, so.
Right, yeah. This is a little clearer. I think what I gave you that was a little clearer, and that's why we kind of
Yeah.
redid it too, because I know last time the board was concerned about what.
This addition could be put on without bringing it closer than 10 feet, just by moving it off. Right now, it lines up with the wall. It's flush with the wall.
Do you want to address that?
I mean, I don't see a hardship.
Address it again.
It's hard to figure out a hardship here anyway to ask for this relief, but certainly not a hardship that says it has to be exactly this width and that wall has to be exactly where it is. Why couldn't it be a slightly smaller mudroom and not have the corner not come closer than 10 feet?
Nick, can you put, I was going to say, can you put that picture,
Yep.
I guess, the back, right? And then can you kind of show us where you're doing this in relation to the triangle? Can you move that thing, no, move it the other way, so we can kind of look at the triangle and the picture at the same time, so maybe we can, people and us can kind of get an idea of what you're talking about. Right, there you go.
I think, so that it looks just,
Okay, you have it up.
Now it's upside down.
You can't do that.
You really want to make it challenging.
If you look at that.
well, if you stand on your heads.
They're looking at it in that way.
And we're looking at it on our screens here.
So this window right here,
Well, ours are darker.
I'm sorry?
Comes out darker on our screens for some reason.
This is A8, actually, if you looked at A8, if you had that there.
A8, Noah.
Okay, got it. Much better.
So the extension really comes right off back from this screen door here, straight back, and then just squares off. Originally, the original plan, the original proposal that we brought forth, squared it off, and in this revised proposal, the feedback that I took away from the last session was you are impinging further than we were comfortable with, the board was comfortable with, and I walked away from if there was some movement that we could make that would be helpful. And so what we tried to do was cut that edge there along this corner, triangulate a little bit, and
Can I, not to interrupt, can I ask you a question?
Sure.
Looking at your picture, to the right of the screen door, as I look at it, how big is, how wide, what's the dimensions of that flat siding piece? And what is that?
You mean running to the downspout from the?
No, yeah, from the downspout over, correct.
I'm going to make an estimate that that's about 2 feet,
No, it can't be.
It's got to be more than
3
that.
feet maybe.
That'd be bigger.
I would say between 3 and 4 feet.
How wide are those windows in the dining room, if that's the dining room?
Are these the windows you're talking about?
The
other ones.
the four tall windows?
No, the full, that is the family room.
Okay, how wide are those windows?
I
That'll
don't
give
know
us a
that.
scale.
I'm going to say they're 3 feet, minimum 3 feet, so that thing's got to be 4 feet.
Yeah.
Why can't you slide that, instead of starting there, why can't you start at the downspout and move it over? If you do that, you're almost going to lose that whole space. I mean, that's blank space anyhow, so it's not like you're going to cover a window. In other words, you said your thing's going to start from the screen door over to the end of the building.
Right behind that space that you're talking about is a bathroom, right there, and these windows right here are the kitchen.
But you're going to cover them anyhow.
Well, in essence, what we would be doing, we would not be covering them. In essence, this is just pushing it back. This is not where the mudroom
Okay, I
is
understand. That's what I
going.
mean. The kitchen's going to get enlarged.
So
I understand that.
Well, no, the kitchen will not be enlarged. The kitchen's actually slightly smaller, about the same, slightly smaller from what it is today. The mudroom is going in front. If we go back to, I guess, A10, you'll see the steps up towards the front of the house along the side, and that's where the mudroom would be. The driveway does not extend all the way back due to the width that we have there. So the idea is you'd be able to go from the driveway into the house, into a side entrance in the house. We really don't have any type of side entrance into the house. So the idea is you would go there, and to put the mudroom there, it's just pushing the kitchen back.
Well, that bay window you have here on the porch,
Yes.
like, if that were the wall that you extended out and went to where Charlie said, to the downspout, wouldn't that give you a similar size without occluding any windows that weren't going to otherwise be affected? Wouldn't that give you all the same things you're
I
looking for?
apologize, I'm not sure I'm completely understanding what you're asking.
From-
If
from
you're
looking
saying
at your
just taking
plan-
those windows and pushing that
Yeah,
back?
from looking at your plan, it seems to me, tell me if I'm wrong, that you're
Yes.
taking the side of the house and you're just extending it out, and then you're going to truncate the corner to come a little less close to
To
the
minimize the
sidewalk.
infringement,
Right.
correct.
But instead of starting at the side of the house, going flush with the house, if you moved it over to, for instance, where this, I guess that's a bay window is, and then ran it over to where the downspout is, wouldn't that give you the same area and just shift it over a bit? I know structurally it's a little different because it won't tie into that structural wall, but it's not that hard of a problem. And then you don't come closer than 10 feet, and then we don't have any problem with what you're asking to do. But to build a principal structure closer than you're allowed to build an accessory structure is I think it's maybe a little too far of a request.
Particularly as I read your plan and look at the Jaeger addition and just shade the Jaeger addition, the intrusion beyond 12 feet is also a variance, and I'm just eyeballing it, but it looks to me like your new addition is at least 3 times the gross area, the square footage of the Jaeger addition. And again, we have to give variance relief not only for 10 feet and closer, but it would also be between 12 feet and 10 feet. So as I see it, it's I mean,
It's a lot.
What's the problem with beginning the addition on the north side,
On the north,
offsetting
on the
from that
north, on the
wall,
north side, yes.
and bringing it out from the downspout? What's the problem with doing that?
I guess I will just say that architecturally, and we went through many, many plans with the architect, the kitchen runs along that edge wall. So you're basically taking the kitchen and then jutting it in, reducing it in size even further than what we're doing right now in order to be able to minimize it. So it does create some additional challenges.
I'm not sure I understand how that would make the kitchen smaller. The kitchen's in the Jaeger addition, right? On the same size as the proposed addition.
That is correct.
So isn't the mudroom going to be like where the porch is and then come out even further?
I'm sorry, where the porch is. There's no porch really.
Well, okay, the steps, from this perspective, it looks almost like a porch, yeah.
The entrance to the mudroom is here.
Oh, that's the
The
mudroom.
mudroom's going to be back here.
Can I come up and take a look?
These are the steps to the
The
mudroom.
mudroom's going to be
That's,
here.
that's right. So we're going to punch a hole right here, put a mudroom here, which is
slide
right
the
now is the
kitchen
kitchen,
back?
and slide the kitchen. That's exactly right.
Okay, so why couldn't you do that?
Well,
Why couldn't you slide the kitchen back?
and in
Just-
sliding the
just
kitchen,
Instead of having it go here, have it be here. It would still give you the same depth.
I'll tell you one reason why you wouldn't like it. Aesthetically, it wouldn't appeal.
Well, certainly.
Rear view, but you'd solve your problem.
Excuse me, gentlemen. I'm not,
Yeah, I'm sorry.
sorry,
just so you know.
that's your
Okay,
pet.
for the record, what we're looking at, for those watching us, is apparently, the public can see these plans, can they? I guess they can. That the mudroom is going where the side steps are, and then the existing kitchen is going to be moved further rear in the lot. The question
Correct.
is, can you just slide it over from, on that plan, right to left, get the same size? It would create like a step, I guess, in the kitchen. There'd be like a corner, an interior corner created. But it could be done.
It would impinge on, I mean, to the extent that we would minimize or reduce to that, you would cut off a certain number of square feet. I don't know what that measurement would be, but if you basically have to go to this line and cut it straight back, I mean, you're talking probably 20 square feet. I don't know. You certainly have this 7.8, and then bringing this straight back.
As you show it here, is this already going as far as where that downspout is? I don't know where that is.
Well, it's not, it's going to the screen door, he's
Only to the screen door?
Only to the screen door. So that's why I asked him.
No, it would be going to the downspout.
Oh, it is, as
Would be
you,
going
as
to
you
the
plan
downspout.
it?
Yes.
Oh, so they can't just take it and shift it without losing area?
Yeah, well, but that's
right.
not what he said
I'm-
originally. What he said originally was it went from the screen door to the end of the building.
That is my bad. He's correct. It is going out towards the downspout.
Okay.
It's stopping right before the windows.
Yeah, and you want to use that roof line, obviously, visually,
Exactly.
yeah.
Exactly.
I mean, it's
So we're
not
trying to be
our role.
arbitrary.
It's not our role to like suggest design to you.
I
But-
understand.
But we are supposed to find a hardship and then grant the minimum relief necessary to alleviate the hardship. So when we talk about, well, can't you shave this here? Or we're going to, should we decide to grant something, what is the minimum that will accommodate your hardship?
I certainly understand. I mean, obviously, based on the shape of the property, it's very difficult for us to be able to try and fit how to do things. Again, we were here in December. We had tried to bring that line straight back, which have made it 7 feet. Nick, I believe you brought the old one.
A6, I believe?
Yeah.
Where we went to 7 feet, and the feedback that we got, or the feedback that I understood from the group, was if there's some way to be able to make some compromise, bring that down some, that would be viewed positively. We sat with the architect and decided to just cut that corner some in order to be able to help reduce it. I understand that obviously it still is an increasing nonconformity. It was our attempt to be able to try and stay architecturally appropriate with the house and do what the board was asking us to do.
I understand.
I certainly understand what you're
It's
saying.
a challenging design problem, I understand, especially if you want to maintain the efficiency of the kitchen and stuff.
And again, and I'd say that's...
But when we say, can't you reduce the intrusion, the target we're looking at is 10 feet. That's kind of a magic target because of the restrictions on even accessory structures approaching the sideline.
Yeah, as you said, it was difficult if you look at A6, because initially we had the building coming straight back here, following the architectural
Right.
side of the home, and then
I mean, we appreciate the
Bruce has said,
creativity in
just
trying
cut it
to
back
accommodate our
try to-
concerns, but, I mean, if the property were useless, or incapable of a reasonable use as it is, I think there'd be more inclination to show the kind of flexibility you're seeking, but it is usable and has been used and can be used. I realize this is more desirable, but does desirability justify encroaching that far with the principal building toward a sideline in this district?
I mean, obviously...
I'm not inclined to think it does, but
I think also,
me.
in fairness, it's the area that for which a variance is being sought is not simply the portion of the addition that's closer than 10 feet to the line. It's the portion of the addition that's closer than 12 feet. That 10-foot is, a target that Mr. Cutler finds helpful. But if you look at the area of the proposed addition vis-a-vis the area that was granted as de minimis relief in 1995, it looks to me like the new addition is 3 times roughly the size of the old. And if you just take a look at the area between 10 and 12 feet in the new addition, that area alone looks like it's at least double what the square footage was that was granted in 1995. And it was 1995 was granted as a de minimis variance, and I certainly don't challenge that, but you can't have more de minimis variances and bites. At some point they add up, and I think that this board has to take into account that you've already had the de minimis variance bite, and to me, as this board solicitor, there's a very real argument that the rest of this has to be treated as a straightforward dimensional variance that's not de minimis, and then you get to those questions of hardship and so forth that are I sense some of the board members have real concerns with, and which I think are valid concerns.
Again, what I'll suggest is the house is from the 1920s. Obviously, it was built originally for lifestyle in the 1920s. The Jaegers had done some addition on there. We believe that there's a little bit more that is worth doing in order to be able to maintain the house and the kind of desirability. I mean, obviously for our own living, but based on the neighborhood and what prospective buyers would expect of a home in the neighborhood.
I think that little piece you have that's outside that 10 feet, I'm not really sure. It's, you got 8.5, you got 7.8.
At the closest, at the furthest point is 1.5 feet beyond. As I said, it's kind of like a
Yeah.
little triangle.
Nick, you
It's
got to get it
actually
to 10
less.
feet.
Okay,
We're willing to go closer than the 12.
okay.
Right, but
But-
you got to get it to 10 feet. Nick.
10 is kind of holy.
Give me a minute.
I can give you 2 minutes.
Okay.
Thank you.
Yeah, that's what we would ask. I think what you're talking about, if we do go to 10 feet, we may want to go back a little bit further to at least make up for the space we're missing.
Okay, okay, you can, redo the plans, but you cannot encroach any greater than 10 foot to the side yard.
We understand that.
Is everyone kind of in agreement with that? Is that okay, Noah, with you?
Yeah, I mean, we're not going to take a vote because we don't have something to vote on,
Right.
but as a
Oh,
matter
I'm
of
sorry.
principle, I would find that.
Yeah.
Oh, you're not voting right
offensive.
now, you're just
No.
trying to.
Right.
okay.
As a matter of principle, I don't think that would be a problem.
Right, because I mean, it is a triangular lot, and there is some basic hardship relative to the 10 feet, but I'm not sure there's a hardship to 12 feet or greater than 10 feet.
But again, I think the bottom line is legally and morally, the board doesn't make a decision until we have a formal vote. So I think you're getting the sense of the board members as to what they're comfortable with. But the vote doesn't happen and can't happen under Pennsylvania law until we actually have a vote on a plan.
I understand.
And if we didn't make that clear the last time, I'm
Oh,
sorry.
we do that,
I'm
yeah.
sorry.
we're totally clear there.
Okay?
So I guess I would just ask the exhibits to be part of the record and,
Are you going to continue the?
oh, do we have to continue? Or I was going to hoping that we would
further
just.
back a little bit than
Yeah.
the box.
If you're going to make
Yeah,
it, if
how
you're
much
going to,
further
if you're
back?
going to, I think John thinks,
Okay, all right, let us, yeah, we're
Jim,
going to
you
have
got
to
something to
continue
say?
then. Bruce, we'll have to come back next month then.
if
Okay.
you're going to make it longer, if you're going to stay and just get rid of that one corner, then we can mark the plan we have,
No, I
and you
think
can
he
be
may
on your
need-
way. If
he's
you're going
got
to,
the-
extend deeper, then I think you're going to need new plans. Is that right, Ken?
Yeah, he's going to have to sit with the architect.
Yeah. Okay, you're going to bring in new plans?
Yeah, so I guess just for clarity, and I understand this is not a vote type of situation, but the direction that I'm being given here is just to stay within that 10-foot line.
Correct.
And if I
You
stay
should
within
not
that
exceed-
10-foot
You should
line,
not
that's
exceed
viewed
side yard of
positively.
10 feet. And, we would consider that,
Keeping in mind that if you went 20 feet back along the 10 to 12 feet, that might be a little more.
That would cause other problems at home
That's
as
right,
well.
yes.
So.
Decided you wanted to have an unusually shaped great room in the back, like a trapezoid or something.
As a point of clarification, if the existing nonconformity is 10 feet,
No, it's 12 feet. The protected nonconformity.
It's 1535. He's asking for 12 now.
Exhibit A5 has a dimension of 10 feet on there.
Yeah.
Right.
Yeah,
Yes.
but that was because a variance was given to add that one little triangle years ago. It wasn't a variance
He had a
changing the
variance of 10
sideline.
foot years ago.
They were allowed to violate the sideline as to that triangle. They weren't, the sideline wasn't altered.
The area that's protected by the nonconformity is 12 feet away. A de minimis variance was granted for a very small triangle between 12 and 10 back in 1995. But anything closer to that property line than 12 feet requires variance relief, and it's my advice to the board that the de minimis card was played in 1995, and that we can't add more de minimis bites above the de minimis. I think this has to be treated as a
Right.
dimensional
In other words,
variance case.
we don't feel as though exceeding the 10-foot that he was given in 1995 is something that we would entertain. Okay.
So
I'm just,
Go ahead. You're smiling.
no, I'm
Good.
smiling because two of you have spoken, which is generally a pretty good feel. You know, I wasn't quite certain where some of the others felt, but
I think you have
that's not
I think you have a
my,
pretty good feel.
I think the views that have been expressed are shared amongst members of the board.
okay.
And if I can, just because, as you'd imagine, going back to the architect and re-looking at and drawing, there's additional expense and such. I just want as much clarity as I can,
Yeah,
understanding that I'm not getting a
I
commitment.
think your lawyer knows exactly where we stand. He's been in front of us enough times that he's comfortable with how we speak.
Thank you.
Thank you.
Thank you. Are you going to ask for a continuance?
I would, so request a continuance on the matter.
And we have the extension of time to hear it, and then the 45 days beyond the closing of that hearing.
That is correct.
Okay. Everyone in agreement with that?
Yes.
Agreed?
Okay. Thank you.
Thank you.
Appeal 2873, the applicant John Riley, property located at 381 Grange Road, Wayne, Pennsylvania, zoned R4 residential. Applicant seeks relief to construct an addition to their home which will encroach into the required front and side yard setback. Applicant seeks a variance from Section 28030C and Section 28030D.
Hello, Board. My name is John Riley.
Sir,
and-
if you'll let me swear you in.
You need to swear in, please.
You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Swear.
And state your name for the record, please.
John Riley. Hello, everyone. My name is John Riley. I'm the homeowner at 381 Grange Road. I'm here representing my wife and my 3 young daughters and seek of a variance of a frontal and western side setback. I have with me my westerly neighbor, the most impacted neighbor of this setback variance, Sunil Menon, right here. And you'll also see in my application there was a consent form provided by my neighbor on the east.
Yeah, I didn't have that in my package. Does everybody have that?
I didn't have the consent.
Yes, we didn't receive a consent form. You referenced it, and I looked for it, but I didn't see it.
Do you have a copy of it with you?
Let's see if I do. I cannot find a copy with me at the time. I apologize for that. Okay. I don't have it with me. I thought I had submitted it, but apparently not. Okay, so as you can see by the depiction on the drawing,
Excuse me, are those people here present in the room?
on the easterly side?
Yes.
No, they are not. They're away on holiday in
So
Florida.
We'll just have to consider them just not speaking on the issue, really?
Yeah, I mean, if they're not here, they can't propose it.
They're not here, and there's nothing for us to see, so basically, they're not for or against, they're just not here.
Understood, understood. So as you can see by the drawing, we live in an irregular
Excuse me,
shape.
can you bring your drawing, because they can't see it? Perfect, great, thank you.
As you can see, oops.
Maybe you can center it because they magnified it.
You know what the weather people go through when trying to work with.
So as you can see, this one.
To push the button.
Testing? Okay. So as you can see, our existing dwelling sits in a current frontal nonconformity, and what we're seeking is to build a garage to the left-hand side, a two-story structure there that would accommodate the size of basically a minivan, which would fit comfortably to allow us to get in and out and go directly into the house, going back through a mudroom, and then an addition on the back. Although it seems as if the addition is grand in nature, I'll remind you these are modest-sized homes. We currently live in about a 1,600 square foot living space, and we're looking to accommodate our growing family in order to stay in the neighborhood which we desire. So we've been looking for over a year and a half at different neighborhoods, and the bottom line is we're living in our dream neighborhood right now with 28 kids under the age of 7, and are looking to build an addition in order to establish and accommodate our growing family. You'll also see on the northeast side an ash tree, which we don't want to encroach on, so we're looking to build off of the northwest side. We're not looking to encroach on the rear setback, and we're looking for approximately 5-foot variance from the side setback, and that would still allow for approximately 75 feet from the edge of the proposed structure to my neighbor Sunil Menon's house, which was built after the neighborhood was put in.
Well, can I interrupt a second? Now, you're saying the distance from the proposed 16-foot wide garage to the sideline with Menon would be how much? It's not on the plan, that distance isn't there.
Oh, no, to their structure, to their house.
Well, what would the dimension be from the corner, the front corner of that garage to the sideline with Menon?
I believe it's approximately 12 feet.
So, I mean, that's a very important number, and it's not on the plan,
Okay,
because that helps us determine what the encroachment is.
okay.
So that's 12 feet?
Do you know that's 12 foot for a fact?
I don't know exactly.
So it
That's
could
an
be-
estimate.
It could be 11 feet, it could be 10 feet, you're not.
Yes.
Has this been designed, this addition?
It's in the process of being designed right now.
Is there an architect or an engineer?
There is an
involved?
architect, yes.
I mean, he hasn't measured that?
I'm sure he has. He probably just didn't label it on the plan.
Is he here tonight?
He is not here.
I mean, that's a critical issue,
Okay,
is knowing what that distance is.
okay.
And now there's another distance. If you go up that same sideline and you have that little indentation in your property where it jogs to the right and then heads back,
Yes.
back to the lot, what's the distance there from the proposed addition to the nearest point there, that corner? That's also not on here.
I'm sorry, from,
From that corner where those that line of plants is shown on your plan, that runs down your sideline there,
oh, yes, okay.
and there's an interior corner created by that jog. That's that point that's closest to the new addition.
Right.
There's no distance given there from there to the new addition. That's also a critical issue and a sideline case.
Yeah. Mr. Riley, I think our problem here this evening is I think you need to get your architect to put those dimensions on the drawing, because we need to know the exact distances from how much you're going to encroach on the side yards and rear yards and what you're going to do. We can't make a legitimate determination and give you relief if we so desire to give you some relief, okay, with what you have here. We can't do that. You know, we need better plans, and your architect should know that. You know, he needs to put down, you know, where the proposed building is going to stop and what's the dimensions from the end of the building, the closest point to the side yard.
Okay.
Because that tells us how much you're encroaching. And we can't give you any relief unless we actually know the exact dimensions. So he's got to, you know, And I think our rules state exactly what's needed. Did you get, when you pick up your application, did you show the application of the dimensions that we require to the architect?
Absolutely.
And then if that's the case, it's his fault, and he shouldn't really recharge you for redoing and doing them correctly.
There's another
And you may
dimension.
not be encroaching, we don't know.
There's another dimension we're going to need to have also.
Okay.
If you look at the front of the existing home, there's no dimension on the point where that's the nearest to the street line. In other words, the question is your new addition going to come closer to the front line of the property than the existing conditions or not? So we don't know that because we don't have a distance from the front of the property to the front of the house at the place where they're the closest.
Yeah,
So the-
yeah, I think it's there. No, bottom right-hand side, 17-1.
But that's not the closest place. If you look, you see that's a curved line, the front line? That's not the closest point. We need to know the closest point.
Yeah, okay.
There's a dimension of 16.
16, 1.5.
Yeah, but that's behind.
That's to the new
behind-
addition. See, that's not the
That's the
front of
new
the house.
addition. That's not to the existing house.
We need to know the shortest radius that connects up that curve to the front of the house. Because, if you stayed within that, you might have certain rights you wouldn't otherwise have to extend your house to the side. With regard to the front yard only, I'm talking about. If you're too close to the front yard, which you are, you know your house was built non-conforming with current zoning. But as long as you didn't increase the non-conformity along that dimension, you might have rights to expand there without needing a variance.
Yeah, page
But we
one-
don't know that unless we know how close the closest point is today.
Page 1 of the plan seems to suggest that the front left corner of the existing dwelling is 15.1 feet from the legal right-of-way line.
But is that the closest? Can we tell that that's the closest? Because it is a radius, you see.
Yes, and then the other corner is shown at 17.1, so that would suggest that it's the closest.
Unless if you moved over, it goes to 15 or 14.5. See, because it's a curve, I'm not so sure you can tell that by eye. Certainly not well enough to base a decision on as to whether he's expanding a non-conforming structure or
But just so
a
you know, if your
variance.
architect were here, he could answer that question.
But I'm just confused. I certainly understand that requiring the distances on the side, but if 16.5, if I'm not looking to encroach further towards the front,
We have to know that's the case.
Okay.
We don't know that unless we know the closest distance
Okay.
between you and the front. In other words, where is the front yard smallest today? If we know what that is, then we can make that decision, and that might make that part of it easy. Maybe.
the agreement
It's
to
already
the...
there. It's already existing.
Yeah, but they're expanding the front of the house. They're taking it down. The point is, will that come closer to the front yard, which is a radius, the front property line,
I think-
than
I
the
think-
existing part of the
Right,
existing structure?
I think what we really would want is on the front page, you have zoning requirements, you have required, existing, and most people have another column called proposed. And that puts all those dimensions, the closest dimensions there.
Okay.
The other thing we could use are square footages of the areas that are encroaching. One thing that I'm seeing on the plan, and my fellow, you or my fellow, or not my fellow board, the board members can, I guess the solicitor, can tell me if I'm all wet. You had a land swap back in 2007, in which you acquired the back parcel, which greatly expanded your building envelope out towards the back, but you exchanged that for a piece of land on your west. The curved area of your side yard seems to be taken off a corner that did not change very much. It changed, though, a good bit further down, and you still have most of that area. It would be effective is clearly in the front yard, but for that land swap, you would not have needed side yard relief. And I'm going to show you, maybe you might put this on the thing so the board can see it and everybody can see it. There's a yellow triangle there. It's clearly within the side, the front yard problem, but However, if the land to the west had not been deeded, some of that yellow, you might not have needed side yard relief. And I just bring that to everybody's attention. You clearly need front yard anyway, but the effect of that was also of that land swap, was also to put that yellow thing into needing an additional variance for a side yard that it might not have needed had the property line been further west.
So additional square footage,
Yeah,
but
was-
although the
Yeah.
variance past the setback would have still,
Yeah, I think the
Be
question,
required.
if you had not done the land swap, well, the best of both worlds, you got the land swap in the back and had not do the land swap to your west, kept that parcel, I don't think you'd need side yard relief for approximately the yellow parcel.
Yeah,
If I'm
and-
reading this correctly.
and the reason for the land swap was it was so irregular that my front yard effectively was in the front of Mr. Menon's house. So, I mean, it was really deemed unusable.
Okay.
But I have another question about the plans. When I
Okay.
look at your subdivision plan, and we go to that corner, let's see, it's right at the, looking for a north arrow, it would be the southwestern corner of the parcel you acquired from the Calvareses. On your subdivision plan, it looks like there's a little notch of land that goes up and over and then back down toward the front. It doesn't come to a neat point there. You see that? There's like a little area.
Right here? Right here?
Yes, but look at the subdivision. Is that the subdivision plan? No, that's not the subdivision plan. The subdivision plan, I take it, reflects how your boundaries are today. And that's what all your present plans should be based on, unless there's been another change. You see that right there? It goes up and over? Or am I reading that wrong? See, it goes up? If you go from
I
the...
think that's a utility pole right here.
But the parcels start in the title line in the road, and it goes in to a point where it says iron pins set. And then it goes over to the right to another iron pin. Then it goes back toward the road to a utility pole, and then it goes across. So you have a little notch that sticks up there that's not even with your old rear line. But that's not reflected in these plans that we're looking at to see what you propose to do and how far things are away from that. So I'm not so sure that the outline of the parcel is correctly shown on your proposed site plan. And that might be important, because that could affect.
I'm sorry, but this was the portion I bought, right?
Yeah.
The
Yes.
square. So now my new deed comes to here and then over and then up.
I think, can I have my plan back with the yellow?
Oh, I see. You're saying because you added that to your parcel, it eliminated that difference. Okay, well, that makes sense. Thanks for explaining that. That makes sense.
Yeah, he's okay with that.
Can you provide any guidance on, after you have those measures, I mean, the thought process and where we would be if, I mean, looking for a garage to the side?
I mean, we can't give advisory opinions on facts that aren't even known to us yet.
The board cannot sort of say that, you do this and we will guarantee you a decision. We can say that, what was, as you said in the prior hearing, that, the board certainly is not amenable to going closer than 10 feet to the property line, and that's not likely to prove fruitful. But, one of the things, the board has to be able to have plans that it understands precisely, which is why, in addition to distances, I'd like to know the square footage. The other thing is, you don't have counsel. It strikes me that you might want to get counsel on this, because, there may be some arguments in your favor, and we can't give you legal advice, and I can't give you legal advice. I've only got one client, and that's the board. But this strikes me as an application you might want to take to an attorney who is, and we have, several people who practice a lot in Radnor Township, and you could, do that. I think you might want to think about that.
By the way, do you need that 16 feet wide garage? I mean,
I believe we do, in order to accommodate a minivan and opening car doors with baby seats and in and out. I believe that would be the minimum we'd be seeking.
Well,
Yeah,
if
that's
you're
why I
encroaching,
think
that could be an issue, just so you know.
if we're encroaching, that could be an issue, that minimum.
Keep in mind, as we had with the last case, in your zone, you have 2 side yard requirements. One is for a 12 minimum on either side, but there's also a 30-foot aggregate. So when you reduce one side yard, you may really be violating 2 different requirements of the same side yard provision.
Understood.
So there are implications, there are double implications to every addition to the encroachment.
Your plan needs to be drawn by somebody who understands our code and can read it and understand what the requirements are. And then in this particular case, I think you would be well advised to obtain counsel.
Okay. Can I ask for a continuance?
Yes, I guess the question would be how long you would want it. Do you want to come back in March, or do you think you need more time to get this done, think it out, and have a chance to pursue an attorney? You can ask for whatever you want. When you do ask for that, we request the board asks that you give us a continuance to start the hearing to whatever the continued date is, and then an extension of time beyond that date to render a decision, which is 45 days. Those are the periods of time that we otherwise would have to vote now, and that probably wouldn't help you very much.
The other critical issue is hardship. You really need to establish a hardship to justify this. This isn't just taking a patio another foot closer to a side yard. This is a substantial addition, given the size and nature of this property. And you really have to come up with a hardship that's going to hold water when you consider how you may want to amend.
Do you understand what the hardship concept is?
Certainly, certainly. So I think
It's not that your property would be more valuable or that it would be a good idea. Hardship is a really compelling thing that is not quite your property for a dimensional variance. Is not quite, you can't use your property, but it's more than convenience, where the dimensional requirements are burdensome to comply with. So I should be released from them, and that an attorney can help you very much on that point.
Yeah,
It's also a
Mr. Riley, I really think you should probably get yourself an attorney. I think
Well,
in the
that's
long
his
run,
decision,
Yeah,
But there's also the concept of self-creation in hardship. We don't grant relief when it's self-created. I mean, for instance, you went into this land swap, as our solicitor has mentioned, and you changed your side yard. And if that made this situation worse, you may have created one of the hardships you may wind up alleging. Also, you bought a house without a garage, with a driveway and no garage. It isn't like something happened and you lost your garage somehow. You bought a house that way. Now you're saying it's not good enough. Is that a real hardship? Where did that come from? Came from your change and what you expect of your house. It didn't come from something that you didn't have control over. So again, these are serious issues if you're looking for this kind of a variance.
Board members, I would like to comment on the land swap issue. If that land swap did not go through, he would have actually been required to have a 30-foot rear yard along that area. So he's gone from a 30-foot rear yard to a 12-foot side yard in that instance.
And I think if I'm reading this, although again I don't have plans that are sufficient for me to find this, it sounds to me like the effect of the land swap was to make a lot of the rear part of the addition conforming, assuming we're okay on impervious coverage and building coverage, but to place a area in the front to the front of the building that would still be non-compliant with at least some of the front yard, but might have been more compliant with the side yard. So, and it comes as a package as to whether, and the board would have to vote on how it felt about, the swapping, gaining ground in the back to creating problems in the front. Although as a general rule, certainly if you had been conforming, if you self-create the hardship, then you're not entitled to relief. query when you're conforming, you don't comply with the front yard under any scenario, but you used to comply with the side, and now you still don't conform with the front, but you have now also rendered yourself conforming, violating the side yard, and that's that yellow area. And I'm doing this on plans that are not detailed enough for me to be sure, so I'm seeing this issue, but I can't react to plans with these issues, failings in detail.
Okay.
Would you like to continue? Did you decide you think March or April?
What is the date of the March meeting? Do you know?
It's always the third Thursday.
Right. Do you know what that date is offhand?
I'll be missing the March meeting. I notified everybody.
Okay. If I ask for the March now, and for some reason I need to go to April, can I ask for that? at a
March
later time?
15th is the date.
Okay.
I think I would, if you're close, I'd ask for April. I mean, you're still well, before the building, season anyway up here. I mean, what is April's date?
The 19th.
19th.
I think I'll be prepared by the March date, though.
Okay.
I think so. Okay.
And you grant us an extension of time to hear the case till March 15th, the March date, and then the 45 days after that to render a decision?
I do.
Okay.
Now, whether you choose to get a lawyer or not, it's your business, but you probably want to have an architect or engineer come with you next time.
And be here to testify.
Okay.
Okay, everyone okay with the March continuance?
Yes.
All right.
Okay, very good. Thank you, Mr. Allen. We're going to take a quick 5-minute break.
But I mean, from our perspective, the issue is the provision for which he seeks relief now.
This was so this would have been a rear deal, it would have been the side, rear, and this would have been rear all the way through here. So he actually made
Appeal 2874, the applicant, the owners of Chili's Restaurant, intends to construct a building which was destroyed due to fire. Applicant seeks relief from the Radnor Township Sign Ordinance 280116 by way of variance. A special exception pursuant 280101B1 or 2, or contends that the relief is permitted as a right as follows. 1. 28122C2, sign height not to exceed 15 feet. The sign destroyed by fire was 21.21 feet 2 inches above grade. The proposed sign will be no higher than 18 feet 8 inches above grade. 2. 28122C2, maximum sign wall area for wall signs not to exceed 50 square feet. 3. 28122C3, applicant proposes a sign above the covered entrance area which complies with the height requirements. Applicant seeks relief from the requirement that it be placed no more than 14 inches from the base of the awning and that the letters be no more than 8 inches in height, or in the alternative from 28118 regarding distance from the wall. 4. 28122C9, applicant proposes an instructional sign on the side of the building which exceeds the height requirements of 6 feet above existing grade.
I actually did a little table also. I'll hand up to the board, Nicholas Cornelia for the record. And then I know we probably want to discuss if we've asked for all the relief that's necessary before we even get started. But a couple things preliminarily. I showed to John the power of attorney, and I do have the original that'll hand up. And I've marked it as A13.
The original should go to Charlie.
Thank you.
Does anyone else want to see?
Nick, can I get a copy of that, please? Behind you.
Over there. And from the sky.
And then here's the table, and if we want to go through and make certain that we ask for everything.
Is this A14, Nick?
This is A14.
Thank you.
Yeah, I know. Well, that's. And I know there was something, Mike just saw something on illumination, and we will comply with the code on illumination, correct? Well, I'll have him sworn in, but yeah, there was something I noticed we pulled out in one of the exhibits, and the illumination on that exhibit was not according to code.
Why don't you swear your witness?
Yeah.
I have a bunch
Sure, you have
of
other-
questions and facts that we need to ascertain, and we may as well put them on.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes, I will.
State your name for the record, please,
Mike Longley,
and spell that.
Longley.
And just, Mike, what's your position with the applicant, Grayling Corporation?
Director of Construction.
And just going quickly through a couple of the exhibits, I've handed up as A13, the power of attorney, correct?
Yes,
And A2 is the deed to the property,
yes,
all right? And A3 was a memorandum copy of the lease to Grayling,
yes,
and actually an assignment, I think it was. And then A4 is a letter from the owner giving permission to proceed here this evening.
that's correct.
Okay, and then I've marked as A14 what I interpret to be our needed relief, and I look to the board to see if there's anything else the board thinks is required after they had reviewed the plans that had already been submitted. I can go through the plans, but I was thinking that if we need something else, we may as well get it out now. And Noah, I know you had some items, I think.
Yeah, some of these are questions, some are issues I think need to be addressed.
Sure.
Because if we grant relief, we need to make sure we do it in the right way under our code. So it's no particular order to these. Let me just go a few things. First of all, I know you've mentioned freestanding sign or signs. Is there more than one?
No, there's one ground sign. It complies with the code. And matter of fact, the
Previous
fa-
variance was for
Pardon?
that. The previous variance granted.
Oh, no, there was no previous variance.
You gave us one. It was for a
Oh,
sign.
no, was that for us?
I thought that was for a sign.
I thought. I know that was granted by
For the
permit.
erection of a freestanding sign
Oh, that's
set
a
10
different-
feet
yeah.
back from the curb.
I don't think that's the same one because the only reason I say it's not, this was from 1967, which was before Chili's got there. We have a permit from 1996, which is when that freestanding sign went up there, and it's less than 30 square feet.
Okay.
So I assume that.
So that
you know-
variance is
Yeah.
irrelevant, except it was a prior variance affecting the property.
Yeah, exactly. Yeah, the application says attach all variances, so that's why I attached it.
Okay.
But they are going to replace the face of that sign, which is permitted. They're not replacing the structure or anything, it's just the face, but there's no need for relief on that. And that sign complies.
Right, but it affects relief. In other words, is that a two-sided sign?
Yes.
Okay. Is the sign, this is going to sound technical, but there's a reason for this, is the one face of the sign at least 2 feet from the other face of the sign?
I don't believe so.
Is the sign illuminated from inside or from outside?
Inside.
It is, okay. Do you know what the square footage of the sign is?
Yeah, we do.
But it's both faces. You see, our code, for whatever reason, defines the double-sided sign as being one where the two sides are the same and parallel, but at least 2 feet apart. And if it's a double-sided sign, it meets all those requirements, then you only have to consider the area of one side when you're figuring your total signage allowance for the property and for a given, for all the property.
Yeah, now I know what we're doing. We're just replacing the face on that. We're not replacing the sign
No,
at
I'll
all.
tell you where I'm going, though. When we compute how much signage you're allowed to have on the property, we have to include the area of all signs on the property, whether they're new or not.
We're not even going to be close.
Okay, but I mean...
Yeah, I know what you're saying.
The fact needs to be known, that's
Yeah,
all
okay.
I'm saying. I don't
Yeah.
know that it's a problem.
I know what I have down here is 28 square feet is the existing sign and what is being proposed here also, and I guess I'll hand this up too. This
But is that
shows
28 feet one side or two sides? 28 square feet.
One side.
Okay, then it should be twice that unless it's less than two, unless
Yeah.
it's more than 2 feet apart,
Okay.
2 or feet or...
I mean, as I said, I don't think we're going to be close. Assuming, for now, we'll assume arguendo.
It can be a...
No, but I think we're not even going to be
2 or greater
close.
has to be.
Because I think the code says it's for all signs.
That's what it says. All right. Okay, the other thing we need to know is the length of the building frontage is something we need to know.
I have.
And it
is-
wasn't on the plan.
Yeah, it's on the deed.
Not the property, the building frontage.
That's building frontage is,
No, the deed wouldn't name the building frontage. It
Deed
would
wouldn't
be
have
property
the
frontage.
improvement frontage.
go ahead.
65 feet.
65 feet. Okay. At some point, we're going to have to do some computations, but now that we have this information. Okay, with regard to sign number 1, what you call sign number 1. As
The
I
wall
see,
sign? Is that the wall sign? Which
well,
one?
it depends which one. I think that's the chili symbol.
Right.
Okay,
Right.
chili symbol.
Yep.
So you had an issue as to height, potentially size, after we do the computations, and the internal illumination. That's an internally illuminated sign.
Yeah, and that's, go ahead.
And
It
then
will be, yes.
you're going to eliminate internal illumination?
No, it will be an internal illuminated
Okay,
sign.
because that's not prohibited in this district. Okay. The other thing, so that would be a variance that would be necessary. You'd have to
Or,
answer that.
well, we're decreasing an existing nonconformity on that.
Well, let's talk about that, because that affects a bunch of things. You know, we give you certain rights to rebuild a structure or a building that's been nonconforming and it's damaged by casualty, as long as you do it within certain time periods. And Nick, you're very familiar with that. Signs are treated differently in our code, Nick. In fact, nonconforming signs were not protected. When they passed the sign ordinance They have a specific provision. It's 280-126.
Yeah, but we know that's illegal, and there's case law
Well,
on that.
What I'm saying is, if you want to address that, you're going to have to allege that, you're going to have to deal with that issue, because we have to live with the code. And if you think it's not valid, then you need to deal with that. You're going to need to allege that and do a valid, John will
And that,
speak to the
and just so,
technicality.
the board may be aware, that's never been enforced in this township. And I know, but there's a reason why it was never enforced.
Well, I'm just saying, it's there. We have to live with the code. If it's not valid, you know what to do. If it is valid, or you can make arguments that it doesn't, whatever, but it's an issue. As long as that's in the code and our portfolio is what it is, we can't disregard that it's there. Now, we can grant relief if we want to when you make your arguments or whatever, but we can't disregard it.
Well, I was, we were talking, we had a short executive. We had a short executive session to discuss this. I am aware that amortization provisions are not favored in Pennsylvania, and I believe, Mr. Cornelia, you're right on the case law on that. Technically, if you're challenging an ordinance, you have to file a challenge because that has a different publication thing. And until you formally file a challenge, there is no ability for the board to consider the challenge, that the ordinance is illegal. The board, in my view, could say that we're going to construe this in a legal fashion and not apply it, but that's, there's some creaking of words going on right there, but I guess what we can't do without a challenge being filed, because we have no jurisdiction, is to formally consider whether that provision is valid. That's not before us unless you trigger. Again, the challenge advertising is different and more,
I understand.
And if you put it before us, maybe the township and the township solicitor will take a position on that, but right now, I'm sure
It's just, no,
township
as you
solicitor doesn't know about
that
it.
is a very drastic measure to challenge the validity of an ordinance. And normally, we don't want to appear before here challenging validity of Radnor Township's ordinances.
But do you see where this really gives us, does this give us any jurisdictional
What we're asking, I
ability
think,
to grant relief with regard to those issues? If your argument is we are just replacing non-conforming signs with ones that are slightly less non-conforming, so we're making things better, not worse, the answer is this doesn't let us grant you relief on that basis as long as this is in the ordinance and we don't get the right to amend it, that. So that's, it is what it is. And okay, let me go on, because I'm raising these issues so you'll have them so you can think about how you want to deal with
right.
these or
Yeah,
not.
and probably, my initial reaction here would be to proceed with the application. Now, of course, if the application is denied, then I may have to come back and challenge the validity, which, again, you really don't want to do. But
The next thing, with regard to sign 2, and we have the internal illumination issue and all that. I won't beat the dead horse, about that. Now, here's the other thing. I was looking at it, and I was looking at these myriad definitions that are in this code.
I totally agree.
Okay. I said to myself,
what was the best one to fit?
But
And
let me ask you a fact first. It's a fact. I think I gleaned this from the plans. Is that sign not attached to the wall, but attached to that shelter you're building? It stands up on that shelter?
That's correct.
Okay. No attachment to the wall. Okay. Now, let's look at it. Number one, is it a wall sign? I'm looking at the signs that are permitted in the... It's not a wall sign because a wall sign can't be more than 12 inches from the wall, and it has to be attached to the wall. So it's not a wall sign. So we said, is it a projecting sign? If it's attached to the wall and it sticks out more than 12 inches, it's a projecting sign under our code, which would not be allowed in this district. It's on top of this thing. This thing isn't a marquee, so it's not a marquee sign. It's not an awning sign, because if this were an awning, it would have to be on the front vertical surface, and it's not. Your sign sits on top of it. It's a roof sign, I guess, and roof signs aren't allowed. I mean, I don't know what it is. And if it's not allowed under the code, it's not allowed. So I can't find a bottle to pour the wine in.
If you look at awning sign, Noah, it says any sign painted on or applied to a structure made of cloth, canvas, metal. This is a sign applied to a structure made of metal.
Yeah, I
which is
tried
great.
that, but there's another provision that says if it's an awning sign, the sign must be on the vertical face front of the awning. You can't put it on
Yeah,
top.
it would seem
I mean,
to
I
me,
tried-
the
I
way to
tried.
do that is you either put it in the front of that awning, or you put it less than 12 inches from the wall. And then that specific area would be solved.
Yes, if it were
I mean,
attached
there's
to the
ways-
wall.
There's ways of going around that.
And within 12 inches of the wall, it would be a wall sign, which, assuming it meets all the other requirements, would be a permissible
Yeah, and then you
sign.
run into the area requirement for a wall sign.
Well, but I mean, let's deal
Or
with
you
what
put
we
it in
can deal
front of
with.
the other thing
And if it
and
needs
call
some variances.
As long as it's on the front of it, then it's on the vertical part of the awning.
I mean, you're going to need variance
On that,
relief.
on the awning sign, we need, as I mentioned, you'll see in the table that I filed, that the requirement, it can be, the height of the letters can only be 8 inches, and we're asking for 2 foot, 11 inches, and the distance from the base of the awning is supposed to be 14 inches, and we're 30 inches. So I guess 14 inches from the wall is what they're saying, and we're 30 inches from the wall because we're on top of the awning.
Or you put it in front of the awning, and that solves the problem. Because it says, right, it says, doesn't it say on the vertical part of the awning?
Yeah, but it's bigger than that vertical. That vertical surface won't hold the sign.
Yeah, you see A6, it shows where it is, actually, if you have A6
Yeah,
there.
it sits on top. It's
Just
really
on
a
top.
roof sign,
Yeah.
really a roof sign.
And roof signs are not allowed anywhere.
Yeah, and it's less than 15 feet. I don't know how that's.
It's on a
I'm
roof.
I'm still missing why it's not an awning sign. I'm sorry.
Okay, well, let me find this section that specifically says that if it's an awning sign.
It does say, I see here, it shall be located in the vertical face.
Yeah, that's it. Which section are you looking at, Nick?
Yeah, it's C3, which is 122C3.
122C3.
And it does say,
Yeah.
shall be located on the vertical face.
You know, a typical awning sign comes down on an angle, has like a front, like on a shop, and so it might say, you know, Joe's Place on the shop, on the front of the awning. That's all that's allowed as an awning sign. You can't like have the sloped part of the awning painted, or you can't have sign only on that front of an awning. And I was trying to find where to fit this. We don't know what relief to grant unless we know what it is. What does it violate, and what relief
Well,
is this?
And that's why I try to fit it the best place it can be fit into the code.
But I mean, we
which is an
can't
awning.
rewrite the
What type of
code and
sign is it?
create a new kind of sign. We can't say, oh, we're
No, but
we're-
you got to remember, you got to interpret this liberally too. You know that this is supposed to be interpreted in favor of the
I know.
landowner.
And if it were 14 inches from the wall, it's a wall sign instead of 12, maybe we could give you a variance to still have it as a wall sign. But it doesn't even attach to the wall. So, I mean, and roof signs are not allowed anywhere.
Okay, you want to go to the next one?
I mean, it's like-
All right, I think I see your point, but Kevin, this sign.
Sign number 3 is also internally
Another-
illuminated. So sign number 3 is also internally illuminated, and that's an issue.
Right. Which we would comply with whatever the internal illumination requirements are.
And I didn't see anything about hardship in here. Was
No,
there-
I requested variance.
But I mean, there's no allegation of a hardship to
Well, that would be for us
dealing with
to-
each variance.
That's, well, we will have to,
Okay.
Yeah, that's not necessary to get them in front of us with the right variances. That's his burden to carry during the hearing.
Did you discuss the instructional sign?
yeah, that was the instructional sign.
Yeah,
I
the
think. That's
instructional
what
sign
we're
was
talking
sign number 3.
Oh, is that number 3?
I mean,
Okay.
there's a height issue with that.
There's a height issue with
We
that.
know about that.
Right.
There's a size issue that we just have to decide is not a problem by doing the computations. And that one is not 2 feet wide, so that one we'd have to account both sides of the face. But you say it won't be a problem. And then the fact it's internally illuminated, which is a problem for all 3 signs under
Which
the
means they
code.
can't be internally illuminated.
Yeah.
I mean, by complying, you pull the internal illumination.
So you can't light up any sign, is that what you're saying?
Internally.
No, you can't have an
You put
internal
spotlights on
light
it, you just can't light it from inside.
in this district.
So how
No, I don't think does it say you can't light internally, or is it?
Yeah. it
So it
does.
had to be shielded.
Yeah, I don't think it says that.
No,
It says
okay.
illumination.
Let's go through it.
Is it 125D, I think?
There's a section prohibited signs.
Yeah,
119 is
projector,
prohibited
yeah.
signs. And if you go, I wrote all these down. Let's see where it is here. Let me find the right notes.
But it talks about L if that you're looking at, it says illuminated tubing or strings of lights which
No,
outline
no, that's
roof
not it.
lines. I don't know if you're looking at that one. I think you may, no, I think it's
It's S's and Sam. These are what's prohibited. Internally illuminated signs, except as may be provided within this article.
So you go.
But there was no place in the article where it allows it.
No.
It says when permitted, okay, go to the section. you're going to.
125
125.
D. It talks about illumination.
D, okay. Where permitted, this isn't a permit. This says where permitted, you have to do it this way. But it doesn't say they are permitted. You'd have to have a section that says in this place, you
No,
may have
it
illuminated
says
signs.
Where permitted signs shall be.
And where is it
permitted, meaning
where
signs,
is it
where
permitted?
signs are permitted, where the signs are
Then
permitted.
you can illuminate every sign
Signs shall be-
internally.
No, it says signs shall be
Easy.
illuminated only as authorized and appropriate sign permit by a steady
Okay.
stationary light.
Well, okay, that's the argument you'll make. Then, you'll do.
No, I mean, remember, this is a zoning code. If there's ambiguity in the code, it's got to be determined in favor of the landowner. You try to make the code consistent, and what I've been trying to do here is make this code consistent.
Well, we'll
And
have to
The way
see-
you make it consistent is you just mention a phrase, and it says unless otherwise stated, and then it refers to the otherwise stated illumination.
Then make your argument, and we'll have to decide whether we find it to be ambiguous. That's what we'll have to do. I mean, it says you can't do it except where permitted, and I don't see anything in this district that says it's permitted. If we took your interpretation, any sign in this particular district would be capable of being illuminated, because
That is
signs are
correct.
permitted.
Every sign in Wayne is illuminated internally.
Not true.
Almost every sign. You go up and down Lancaster Avenue, and permits have been granted for internal illumination of signs without any issue
are you,
having to appear
you're
before
gonna-
here. Now, I guess the question is, what do we want to do here?
Yes, that's
I'm
what
trying
I'm
get
going to
down
ask you instead of arguing about it.
Yeah.
And you can come
Well,
up
so
with
the one thing I can do, obviously, the illumination, and I poured over this code because I was in here for the Suburban Building, wasn't representing them, but I sat in here for 3 or 4 hearings when, it was
that's
this
right. We did-
board,
we did
you didn't
go
ask
over
for
the
this,
same-
you didn't ask for that, you didn't ask for this, and I attempted to go over every single item of this code. And the only thing...
Now, didn't we allow them illuminate there?
Yeah, that's why I was going to say.
But there was a reason, because they were like 100 feet back down an alley from the street, and if it weren't illuminated, you wouldn't be able to see where the main entrance to the building was. There was a
See,
unique
what I did not
circumstance.
ask for here, I did not ask for relief from the illumination because I didn't see the illumination as an issue at all. So that is not included in here. So if I have to ask for relief from illumination, then I would have to ask for relief from illumination, which I have not done here because, as I said, I did not see that as an issue because D covers it.
Well, one of the
Where we come out about that
But if
would depend
the
the vote.
board's going to determine that it doesn't cover it, then I should ask for a
No,
variance.
where we come out on that depends on a vote, but you need to ask for it.
I need to ask for
you
it.
need to ask for it.
You need to ask for it.
All right, so can we just go over again so that next time I know what I'm asking for?
Yep.
Okay?
Usually you have a bucket at the end. The bucket wasn't there this time.
Yeah, but the bucket, what am,
Okay, all right. Do you know what you need?
I mean, but
Do you want to
really,
go
it's
over
still
what you
got-
believe?
I can't cite every section.
No, but can't you
I
put in,
can't cite every
such
section of
other
the code.
variances or other relief, appropriate relief as may be necessary in order to authorize your sign package? Again, we don't want to have a Luke v. Cataldi problem with advertising kicking around here. And I think if you put a basket at the end of it, I think the argument of ambiguity, if you think the code is ambiguous, is something that doesn't need to be advertised by, we think the code is ambiguous. If you wish to formally challenge the amortization provision, that's,
Yeah, and that's, as I said, John,
I've
I
already...
mean, I can throw that in here, but, they don't have John Rice sitting there, and,
Well, I mean,
It just doesn't-
Just, you know what to do, Nick.
okay, so let's go over.
Yeah, let's go over what, if any additional advertising needs to be done as well.
Right, and I'll put the bucket in.
Well, you've put on the record now the width of the building at the building line, front line, and you've put on the record what one side of the freestanding sign
We're going to have to
is,
find the freestanding sign and what the distance is.
Yeah. to see if you
between
count it
fences.
once or twice, right.
Yeah, 'cause I don't think.
And then somebody's going to have to do the...
Total square footage of signage, so you don't exceed
Then
that.
someone's going to have to do the computations. There are 2 different area limitations that are in the code. You're familiar with those. One is for the total property and one is for any given wall. So you'll need to do the calculations in compliance with that and put that in the record too.
And if you need relief, it turns out, notwithstanding that you don't think you need it now, you need to advertise that relief.
I mean, we would have computed it in advance, but we just didn't have the facts necessary to do that. You might want to think about sign number 2. Is there a way to find a rubric, even if it doesn't technically comply with the code, so we could give you a variance of distance from the wall or something? Can you come up with a way to keep it, to let it fit into a sign that's permissible, possibly with some zoning relief to make it permissible? But like I said, for instance, instead of sticking it on top of the canopy, can it somehow be attached to the wall? Maybe it's too far out, but that we can give you relief for, assuming the right case is made.
Because there's nothing, it doesn't fit in anything. I mean, it's a
No, I
roof sign
still-
now, and it's roof signs,
I don't-
I mean, the roof
still
side,
see it
the
as
roof
long
sign
as it's on
prohibition,
top of a-
the roof sign prohibition is absolute. It doesn't even allow for any possible difference like it does with some of the other things.
I'll ask for a continuance.
okay, till March or April?
No, next,
March?
Next
Okay,
week?
I'm just checking. Just checking.
Well, the advantage of March is, Nick, I've already notified everyone, I'm going to miss the March meeting.
March.
Remember, you got to get your stuff, your advertising request into the township in time to make the advertising. If you need to re-advertise, that's got to be
Yeah, I'm
in.
gonna have to, Kevin, when do you think you're advertising? Monday? Did you already send it in?
I would need to take a look at that, Nick, and give me a call tomorrow, and we can.
Yeah, I'll
that out.
I'll get it to you tomorrow, because I know that normally, no, you probably wouldn't have advertised yet, no, okay. You'd accepted applications, but this is just a continuance, so.
Correct. The application period has closed for the next meeting, but if we're continuing it and we just need to re-advertise, we should be all right.
If there's new relief requested, some of that may have to be,
Just re-advertise.
Just re-advertise. As long as it's advertised, it's okay.
we'd have to amend the advertisement.
Right.
Yeah.
Yeah,
Yeah, he'll put a new advertisement in,
Yeah, put your bucket in there, or basket, or whatever you want to call it.
right, okay.
okay?
And I'll grant
Extension, right.
the extension both to hear the case as well as 45 days
After
to
the
make a
meeting.
decision.
Okay.
Everyone okay with the continuance?
Delighted.
And Noah's not here next time, right?
I will not be here.
No further business in front of the board? It's closed. Yeah, I understand, I understand. I'm here, it says. I've closed the meeting, so if you're,
I tried to raise my hand before you closed the meeting.
but whatever you would say anyhow pertaining to the sign is irrelevant, because he's got to come back in March
I
and
understand.
redo it.
I understand that, but I would just like some information.
Yeah, I don't think she's.
My